This courtroom run isn't one case. It's a parade of bad decisions.
Okay.
Assaults,
Thank you.
reckless driving, weapons,
Sure.
DWI,
December
and a
29th,
judge who's
2024,
clearly running out of
the
patience.
officer
dismissed one of it's the same industry found. That's my understanding.
Okay, good to know. Thank you. Sure. On December 29th, 2024, the officer was dispatched to a residence in Harris County, Texas, and was met at the front door by the complainant. The complainant stated that I apologize, Your Honor. The complainant provided a statement and brought the officer into her kitchen, and the officer was able to see redness on the upper left side of the complainant's face near her eye. The officer also observed on the complainant a small laceration and fresh blood. The complainant had tears in her eyes and stated that the defendant and she had been in a dating relationship for on and off for 6 years, and that in the morning, the defendant and she got into a verbal argument about various issues, and the defendant became irate due to her confronting him about the issues, and he started belittling her and calling her derogatory names. The complainant then stated that when they were arguing, she responded by insulting the defendant back, and then things began to intensify. Eventually, the defendant charged at the complainant, and the complainant stated that the defendant slapped her with an open palm across her face, throwing her backwards onto the bed. And as the complainant attempted to cover up her face by turning on her stomach, the defendant punched her in the back 3 times with a closed fist, and the complainant did feel pain from being slapped and punched in the back. Okay, Mr. Vada, because I'm going to find that there's probable cause to go forward with your case. I'm entering now what's called a magistrate's order for emergency protection. This identifies Ms. Alvarado as a protected individual. You cannot commit family violence.
Sorry.
It's okay. It's not a big deal. Are they prescriptive?
Yes, sir.
Back on. I want you to understand that I'm issuing a protective order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. Threaten, harass, use another person to communicate a threat or harass behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand?
Yes, Your Honor.
If you violate this, the state can and will file a violation protective order against you, and it's one of the worst cases you can pick up. Just don't have any contact, don't have any weapons, and you'll be fine with us. Got a great lawyer. Listen to him. He'll take care of you. Because you have a lawyer, I will waive your appearance, but you have to stay in contact with him. If he comes back, tells me he can't get a hold of you because you've taken off, a warrant will be issued. You pick up a new case, a warrant will be issued. It's not hard. Do you understand? Do you understand?
Yes, Your Honor.
Okay. We're going to have them file all the documents. We'll have you sign it, and after that, you'll be free to go. Okay? Do you want a PR bond?
I just didn't want to fight too much this morning, but
Of course. Please. I just see the stuff from 92. That's all I see, right? Is that it? Okay. I'll grant you a PR bond, but understand this is the only one I'm going to give you. You become a danger to my city. You become a danger to my community. I'm going to yank that PR bond and I'm going to make it high. You understand?
Yes, Your Honor.
It's not hard. All right. Okay. There's a ton of paperwork we're going to have to do. So just pick a date with Victoria and then you're good. Don't leave until you sign all the paperwork, Mr. Rojas. Okay?
Continue.
Okay. Sir, you were charged. Do you speak English?
Yeah.
Yeah. No.
John.
Better. You're charged with reckless driving, up to 30 days in jail and or a $500 fine. Hey, Conrad. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. I apologize, Your Honor. What's the last name of this? Turu Biartes. Turru. Thank you, Your Honor. Sure. Okay. The officers were surveying a known street takeover group in a large parking lot in Harris County, Texas, when the officers observed the defendant's vehicle spin its rear tires and do approximately 4 to 5 donuts in the pit, coming within 10 to 15 feet of other vehicles. Undercover officers kept their eyes on the vehicle until other officers were able to conduct a traffic stop. The undercover officers also identified the driver as a slim Hispanic male with curly hair.
The officer observed the defendant in the driver's seat, and the defendant admitted to doing donuts.
Right. Sir, I'm going to find that there's probable cause to go forward with your case. Have you seen if he has a valid license?
I'll run it, Your Honor.
Please. I'm ordering you as a condition of your bond not to partake in this type of behavior again. No racing, reckless driving, donuts, street takeovers. If I find that you do, I'm going to put you in jail. No more PR bombs. Do you understand, sir?
Yes, Your Honor. I apologize. It's loading right now.
Yes, no problem.
It's eligible, Your Honor.
Okay. Do you mind crafting those orders? We are going to reset your case to give you time to hire a lawyer. So I'm going to have you sign a reset with Victoria. We'll get you in the jury box. We'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Be careful. Don't drive like this again. Do you understand?
Yes, Your Honor.
Okay, ma'am, you're charged with assault causing bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. On December 27th, 2024, the officer was dispatched to a disturbance at an apartment in Harris County, Texas. The officer made contact with the complainant, and the complainant and the defendant are cousins. The complainant and the defendant do not live with each other, and the defendant was staying with the complainant for a couple of days. The complainant stated she and the defendant got into an argument about the defendant's lifestyle. The defendant became upset and started to throw the complainant's belongings out of the apartment. The complainant and the defendant continued to argue, and the complainant tried to open the door to retrieve the belongings, and the defendant grabbed the complainant's arm, applying pressure and scratching the complainant's arm, causing a deep cut, bruising, bleeding, and pain. The defendant stated she had been arguing with the complainant earlier in the day, and the defendant stated she got fed up with the complainant criticizing her and asked the complainant to leave. The defendant stated the complainant pushed her and took her phone, and the complainant's small dog caused an injury, and the defendant did not recall injuring the complainant.
Do you know if alcohol played a part in any of this?
There's no allegations, Your Honor.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case and not to be in possession of any weapons. Do you understand? These are your bond conditions. If you violate these conditions, a warrant will be issued. You will go to jail. No more PR bonds for you, man.
A magistrate's order for emergency protection isn't a suggestion. It's a legal landmine. One text, one visit, one slip-up, and you're looking at a brand new criminal charge.
We will do that. We'll give you time. Yes, we're going to do that now. I'm going to have you sign a reset. Victoria will give you 30 days, but I'm going to have you also take a seat in the jury box. So we'll get you bond conditions. We'll have you sign it, and then you'll be free to go, man. All right? Please. Mr. Ware, you're charged with unlawful carrying of a weapon. You're facing up to a year of jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 28th, 2024, the officer was dispatched to a robbery that just occurred in Harris County, Texas at a restaurant. While en route, the officer observed males walking on the south side of the store where the robbery had occurred, matching the description the reportee provided. The officer called in an attempt to contact the two individuals and located the two males wearing dark hoodies, dark pants, and shirts tied to their heads that looked like makeshift ski masks. The officer made contact and asked if it was okay if they were patted down for weapons, and both individuals ran off. A short pursuit lasted approximately 50 feet, where the co-defendant slipped on a puddle of water, and the defendant ran approximately 5 feet before being grabbed by the officer. The defendant, 19 years old, whilst trying to stand the defendant on his feet to walk him to the patrol vehicle, the officer found on the defendant a loaded Glock 9mm, which fell out of the pant leg of the defendant.
So this is part of an ag rob as well, right?
Amanda March.
Yes, Judge.
What happened on the ag rob?
One moment, Your Honor. So during the ag rob, the complainant stated that while he was walking into the store to grab his food order, the two males stood outside the store watching him, and as he walked out of the restaurant, they blocked his path, and one of them pulled out a gun on him, and the other yelled at him for his wallet and keys.
Where is this?
It was, one moment, there's an address, but not a name of the business. at a Sonny's food store.
Got it. Mr. Ware, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. You no more PR bonds. I'm now also giving you a curfew. I don't want you out in the middle of the night. And I'm going to put a monitor on your ankles so I know where you are at all times. Do you understand? If I find that you're a danger to my community, I'm going to lock you up and I'm going to make your bond so high. Do you understand, sir? No contact with the co-defendant in this case and no weapons as well. How old are you, sir?
19.
Did you graduate from high school?
Yes, sir.
What are you doing with yourself now?
Not much.
Are you working?
No, sir. I was planning on going to the military. I was signed to a military.
I want to know what you're doing with yourself. If you're working, if you're doing anything, because I want you to get a job. Too much time on your hands, you become self-destructive. You need something to do.
Forklift license. And I'm going to a class for forklifting.
Good. Get it done. You need to get a job, and I want to make sure that you're going to get a job. I'm going to provide you a lawyer today, but I want to see here within the next couple of weeks what you have done to get a job. If you've done nothing, life's not going to go well. Do you understand?
Sir.
In this life, you have to be productive. You have to either get yourself an education or get yourself a trade, a job, because I'm going to tell you now, when you turn 40, if you don't have a career, if you don't have an education, if you don't have anything, this life is not going to be a good one for you, because I'm going to tell you, life sucks without money. You need money. Otherwise, it's going to be just a rotten toilet of an existence. Do you understand? So we're going to make sure here you're going to leave better than you came. So you must either get a job or get into school full time. Do you understand?
Yes, sir.
I'm going to give you a lawyer today, and I'm going to bring you back in 2 weeks, and we'll see what you've done with yourself.
Yes, sir.
All right. Todd McLean.
Yes, sir.
Mr. McLean, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
The officer was dispatched to an apartment in Harris County, Texas, in response to a disturbance. Prior to their arrival, the officers were told the defendant was in an altercation with the child's mother, was intoxicated, and had a firearm. Upon arrival, the officers observed the defendant banging on the door to his residence, and the officer told the defendant to show his hands, and the defendant ignored them. The defendant then pulled his handgun from his waist to show the officers that he had it, and then placed it back into his waistband approximately 4 times. The defendant eventually put the handgun down, but told officers they would have to tase him to get him to stop. The officers then attempted to detain the defendant, but the defendant continuously pulled his hands away and kept placing them in his pockets. The defendant was then tased twice, but kept putting his hands back into his pockets. The officers were eventually able to detain the defendant.
Did you say, initially you said he was intoxicated, right? Is that what you
Yes, he was
said?
reported intoxicated.
Okay. Mr. McLean, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs and not to be in possession of weapons. Do you understand? What do you do for a living, sir?
Photographer. Do photography.
Okay. What kind of income do you have from photography?
Income coming in. What you want to know, monthly? Or
Yeah. Do you have the ability to hire a lawyer?
yes.
Okay. We'll give you time. So I'm going to have you meet with Victoria. We'll have you sign a reset. I'll have you get with Felicia for your bond conditions. After that, you're free to go. All right. Please. Okay. Ready? Yeah. Sorry to keep you waiting.
How are you?
Do we have Zuberi, right?
How are you?
Good, man. We have a,
We've been working hard. The case was filed late April. He had a retained lawyer in the beginning. He came to me middle of June. I subbed in late June. I had a couple settings.
where do you want to go? What do you want?
We're asking for about 30 days to flush some stuff out. And I think ultimately What I'm slightly disappointed with is the way the case was presented by the agency to the DA's office. It's not their fault. We've been put in a time crunch where we got to November and we began to run up against your 180 days. And I think we all kind of realized the agency didn't bring over what they needed to bring over.
So are you still lacking stuff?
I think we're all in a position where it's less, some of the initial discovery is complete, but because we're all working so hard, there's some subsequent discovery that needs to be done based on some things that have been said. And so Kelsey's been great. She's working hard, talking to people.
But I mean, what do I need to do? Because we're now at 240 days. We're still missing stuff. It's unacceptable.
I would suggest this is one of those moments where I would say we've all been doing.
Real talk. Do courtroom lectures like this actually change lives, or do they just sound good on the record? Drop your take below. Same courtroom, different defendants, but the message is consistent. Ignore court orders, mix alcohol with bad choices, or cross family boundaries, and the system tightens fast.
This a long time. If you just trust me, I say we really just need 30 days to work on some things and then come back, and I think we'll be in a better position then to know with clarity whether we're working this out or not, and we need a trial date.
Well, then I'll give it to you, Lon, but at the next setting, it's clear trial, you know? Like, that's it.
And I appreciate your position is like, hey, look, I've got and I have an idea of when and how I want to move things. Every now and then things get messy. This one's gotten a little messy, but
Typically, when we face this type of dilemma, what I do is I order them and I subpoena the people who have.
yeah, this is a little different than that. This is different. And if we were in one, and I think you did that back in November because there were some screenshots or something that maybe weren't complete yet. And then so you asked for a compliance hearing, and then some more information was provided, which again really only happened because the agency in the beginning didn't have a detective assigned to the case to really work it up and bring it over. Like, I'm used to a small town like detective work. This didn't happen here. And so a lot of it's been thrust in their lap, unfairly probably. And so she's good. We're all good. Got good
Right,
work.
so-
Lawyers working on it. If you give us 30 days,
I'll give you the 30 days, but at the next setting, it's clear trial. I mean, it's it. Because by then we'll be, you know, what, 275? So we're close to.
track 60 that I wasn't on it.
Yeah, I mean, and that's why I'm giving you the benefit of the doubt.
3 for 1.
Okay, all right, we got it.
Thank you, sir.
Okay, sure. Sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28th, 2024, the officer came to a stop behind the defendant's vehicle, and the light turned green, and the defendant's motor vehicle proceeded, and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated, and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming 1 alcoholic beverage, and standard sobriety tests were administered. HGN 6 out of 6. The walk and turn on 1 leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
It's eligible, Your Honor.
All right. How many prior DWIs does he have?
He has 1 prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're gonna have you wait for him now, but after today, I'm gonna waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right, I'm gonna have you sign a reset. I'll have you meet with Felicia for bond conditions and we'll just have you waiting back for Mr. Stewart to show, okay? Please. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer was dispatched to a disturbance at a residence in Harris County, Texas. And the complainant, the mother of the defendant, told officers that the night before, her and the defendant had gotten into an argument. The defendant returned the next day to get his belongings, and the defendant walked up to the complainant with a fighting stance. And the complainant told officers that the defendant grabbed her wrist, causing pain and scratches, and attempting to pull her. The defendant stated, "No, bitch, you're coming downstairs with me." The complainant pulled away, and the defendant then slapped her in the face, causing pain. The witness, the defendant's sister, also saw the assault.
Mr. Brunson, I'm going to find that there's probable cause to go forward with your case. No, now's not the time. You will have the opportunity. Now's not the time. I'm just trying to find if there's enough probable cause to go forward. If so, what kind of conditions to put on your case, if any? Have you reached out to the complaining witness? Do we know what she wants?
So we made an attempt and she couldn't speak to us at the time we called, so we'd have to reach out.
Okay. Mr. Brunson, because I always like to follow the wish. Stop. I'm letting you know what the expectation is in this court. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're going to sit there and type it and use it against you. I like to follow the wishes of the complaining witness. When I don't know what they want, I'm going to order you not to have any contact with them. I'm also ordering you not to be in possession of any weapons as well. There is a protective order that has been issued in this case, and if I were you, I would get to know it, because if you violate the protective order, the state can and will file additional cases against you, including a violation of protective order, and that is the capital murder of misdemeanors. Do you understand? So get to know it. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria and sign a reset. We will have you take a seat in the jury box while we get your bond conditions ready. We'll have you sign it. And after that, you'll be free to go. All right, please.